Thanks everybody for joining us. I'm Jonathan Poole. I'm the chair of the nonprofit law section. And we'd like to welcome you to today's CLE. It's our second CLE of the year, When Good Boards Go Bad, Nonprofit Governance and Risk Management. I'm going to turn it over to Lauren, who will introduce our fabulous panel for today. But I did want to make one housekeeping note, and that's that we'll have an in-person CLE on March 19th. It's going to be at the Alliance Center campus in Buckhead, and it's going to be from 10 to 2:30 p.m. And you'll see more about that coming up in the next couple of weeks. What we'd love to have you there too. All right, now without further ado, Lauren, I'll turn it over to you.
Hi, good afternoon, everyone. My name is Lauren Bellamy, and I am the vice chair of the nonprofit section of the State Bar of Georgia. And I wanted to introduce our wonderful panelists for this CLE. Our first panelist is Amy Dosick. She's tax counsel for the Pro Bono Partnership of Atlanta and the principal of Mayman Advisors. Amy is the founder and a principal with Mayman Advisors, which is a consulting practice serving nonprofit organizations, their boards and executives. Mayman's services include fractional outside general counsel and executive support, executive coaching, management, financial, operational, and strategy planning and design, and board training and facilitation. Amy also works with Pro Bono Partnership of Atlanta as tax counsel after serving as a longtime volunteer. Amy has a 30-year career in nonprofit sector as a CEO, management consultant, attorney, and public accounting tax advisor, and led the nonprofit tax practices at EY, Ernst & Young, and Cherry Baker LLP. For 10 years, Amy served as the Chief Executive Officer of Girl Scouts of Greater Atlanta, which is one of Georgia's largest youth-serving organizations. Amy brings extensive board service and governance experience to her work and nonprofit. She is currently the chair of the Board of Hillels of Georgia and has held numerous senior volunteer leadership roles across nonprofit organizations, including service as an organizational treasurer, governance nominating chair, human resources chair, and member of fund development committees. Through these roles, she has gained deep practical experience in fiduciary oversight, budgeting, and financial reporting, board effectiveness, executive partnership, succession planning, and fundraising strategy. Thank you, Amy. Our next panelist is Michelle A. Williams, and she is senior counsel at Baker Donaldson Law Firm. As a former in-house counsel at large academic medical centers and safety net hospitals, Michelle Williams draws on her industry experience to advise on regulatory and structuring aspects of complex hospital mergers, acquisitions and integrations, conversions from nonprofit to for-profit status, and successor liability. She also advises on corporate governance in connection with changes of control or ownership. Michelle represents clients undergoing Medicare terminations and advises on hospital authority law, voluntary disclosures, corporate integrity agreements, and key TAM defense. Since 2012, Michelle has been recognized by the best lawyers in America in healthcare law. Chambers USA has also listed Michelle as a leading healthcare lawyer since 2008, and Michelle is also one of our outside counsels. Thank you, Michelle. And last but not least, Andrew Z. Smith is a shareholder at Greenberg Traurig. Andrew is an experienced attorney who advises a wide array of clients, from Fortune 500 companies to small entrepreneurs, on complex commercial litigation and dispute resolution. Andrew is particularly focused on helping clients navigate business disputes and manage risks, offering tailored strategies for litigation avoidance and conflict resolution. Andrew's commitment to leadership and community advocacy is equally impressive. He is actively involved in advancing the rights of LGBTQ plus community and holds several leadership roles within and outside of his law firm. He currently serves as the immediate past chair of the Board of Trustees for Quality Care for Children, where he was chair from 2022 through 2024, after previously serving as chair-elect from 2021 through 2022. Andrew has also completed the LEAD Atlanta program as a part of the class of 2023, and he serves as the president of the Young Alumni Committee for the University of Georgia School of Law. Andrew's dedication to both his profession and his community has earned him widespread recognition. Andrew was listed in Georgia Trends 40 Under 40, shortlisted for the Chamber's Diversity and Inclusion Awards, and recognized by the Atlanta Business Chronicle as a rising star in its Leaders in Corporate Citizenship list. His pro bono work focuses on assisting members of the transgender community in petitioning for legal name changes, which is a cause close to his heart. Andrew is also an active member of Lambda Legal Defense and Education Fund, serving on the National Leadership Council since 2022 and recently becoming the vice chair for the Southern region in 2024. Thank you, Andrew, and we look forward to hearing from all of our panelists now.
Good afternoon, everyone. I'm Amy Dosick, and in both of my roles, my job is to help nonprofits, their boards, and their executives be their best selves. I help with both the legal and non-legal aspects of that. And while governance is not always the most exciting topic, if you were with us for the nonprofit section's last CLE, talking about the uncertainties of grant funding in a very volatile political environment, I would argue with you today that nonprofit governance has never been more relevant or more important. And so I'm going to kick us off this afternoon with some basics of nonprofit governance and talk about, oops, let's see, let's go back to the beginning. That's not what there we go. Can I get a thumbs up? Can you all see my screen with the title slide? Okay, thank you very much. And so we're going to go through some basics of nonprofit governance and talk about sort of what are the rules. And then because rules are ultimately implemented by humans, what happens when the rules go awry based on all the human things that humans do. Because rules are only as good as your ability to enforce them and follow them. And so when we talk about nonprofit governance, you'll see what's here is a Venn diagram. And so as we go through the rules, we will talk about the different bodies of rules under the Internal Revenue Code and regulations, under state common law, under state nonprofit corporation codes, and many of the same concepts will come up over and over again. And so as we go through these different bodies of law, you will see a lot of familiar concepts like conflict of interest and avoiding conflicts of interest, and paying attention, exercising a reasonable duty of care. You'll see these same concepts come up and up again. And so when I think about the body of law that applies to nonprofit corporations, their executives, and their boards of directors, it's really an overlap of several different things. So let's dive in. Our starting point, because we are here in the state of Georgia, is what is in our state nonprofit corporation code. And actually, our state nonprofit code is not that different than many other states, and actually doesn't have a whole lot to say about fiduciary duties. There's not a lot of words there. And so let's kind of unpack what is there, and then we'll talk about how that actually plays out in the law. And so OCGA 14-3-830, which talks about the nonprofit duties of directors, starts with the phrase, unless a different standard is prescribed by law, a director shall perform his or her duties as a director in good faith, with a degree of care of an ordinarily prudent person in a like position would exercise under similar circumstances. When you talk about what does that really mean, it usually breaks down into three basic fiduciary duties. The first is the duty of care, um, to exercise, prudent judgment, um, the duty of loyalty, in good faith, to act always in good faith and in the interest of the corporation and not in your own interest. And then the duty of obedience, following the rules. So breaking these down a little bit more granularly, um, the duty of care has a few different elements to it. The first is really being an active participation. I was doing some work with a board and their executives the other day, and the executive said to me, "We're just going to have the board rubber stamp this decision." They were making a decision to discontinue a major program of the organization that accounted for about 20% of its annual budget. That's something big picture that should be put in front of a board. If your board is a rubber stamp, they are not doing their job. And so the first aspect of the duty of care is being actively engaged. So as a board meeting member, it means you show up. If you have missed a majority of the meetings of your nonprofit board during the year, you are probably not complying with the duty of care. But beyond showing up, it means actively asking questions. If your board uses a consent agenda and sends out meeting materials in advance so that the meeting focuses on iterative discussion rather than just report outs, which hopefully is what your board is doing. You are reading those materials and you're going through them. And as you go through them, you're thinking, what do I need to ask about this? What concerns me? What do I maybe not understand? And you come with your list of questions ready to ask in that board meeting, and that you are actively engaging in discussion. If your board meetings are a series of reports where the board sits there like furniture, that is probably not a board that is exercising its duty of care. Prudent oversight. When we get to some of the examples that I'm going to talk through with you, um, a lot of them will revolve around finance, and that's not the only aspect of governance that is important. But money solves a lot of other problems. And if you were with us for our last session, where we talked about the uncertainty of grant funding and sort of all the other financial uncertainties that face nonprofits, a big piece of this is prudent oversight. And so this means not being a rubber stamp in the budget process, challenging assumptions, saying, do these assumptions that we've made about revenue that's going to come in, the level of our expenses, do they make sense in light of what we know about our current funding streams, in light of the bigger political environment, if you rely a lot on government grants, and maybe having an A, a B, and a C budget scenario depending on some different variables that might happen. And making sure that the organization is actually following the budget. And so if you are 6 months into your financial year and you see revenue has not, hit its targets, or expenses are tracking significantly above what was budgeted, it means holding up a hand and saying, hey, we need to have a mid-year budget discussion. Um, Oops. And, zooming out a little bit bigger, in addition to paying attention to what's going on day to day, partnering between the executives and the board of director on what the long-term vision and future of the organization looks like. And so boards have a key role in strategic planning, at looking at, what is the mission of the organization? Is that mission still relevant in light of changing circumstances? And what else is the community asking you to do? And how do you adapt and pivot and respond to that? And so boards have a key role to play in all of these in the duty of care. The duty of loyalty here, some of the key concepts are avoiding conflicts of interest. And so this means that if you are a vendor that provides services to the organization, it doesn't mean that you can't provide services to the organization, but that you follow your conflict policy, you disclose, you don't take part in the decisions, and you don't try to unduly influence others. Um, Prohibition on self-dealing. So even beyond personal financial interests, this has to do with your larger sphere of individuals, your family members, your friends. And so some of the places I see this show up is where a board member will, put their thumb on the scale in the hiring process and encourage the hiring of someone that's their kid, their friend, their golf buddy, who may or may not be the correct person for that position at the organization. And so, the duty of loyalty means making sure that everything you do in your official capacity as a board member is strictly for the benefit of the organization. It does not unduly benefit you, your family, your friends, or even unrelated parties that are not within the organization's charitable class. The duty of obedience. This is one people don't know as well as those first two duties, the duty of care and the duty of loyalty. In a nutshell, the duty of obedience means follow the rules. And that means all the rules. It means following your mission. And so a lot of organizations, particularly when dollars are short, might be tempted to follow dollars in a direction that is not really within the core of what they do. And so, if you're a youth serving organization, someone might come to you with a grant opportunity, to do human trafficking prevention, but that's not really what you do. So should you follow that grant funding and do that? Maybe, but that's a discussion about what your mission really is. It also means following all the laws that apply to any organization. So it's things like making sure that you've properly classified employees and independent contractors. That you are if you're operating overseas, you're following all the rules against, anti-money laundering and, doing all the things you need to do to comply with any federal, state, or local law. It means following any policies that the organization has passed. So it means following the conflict of interest policy. It means if you signed a board agreement that says, you're going to attend a majority of the meetings and that you're going to give an unrestricted gift, that you've done all of those things. And lastly, that you follow donor intent. And so if you get a restricted gift, you make sure the organization isn't putting that into the general operating fund. And we'll talk about how some of this has played out in examples in a moment. There is also 501c3 under the Internal Revenue Code and two related but separate concepts there. And so nonprofit organizations receive federal income tax exemption under Section 501c3. And 501c3 contains two related concepts. The first is private inurement. And so no resources of the organization can inure to the benefit of private individuals. And private inurement is really concerned with benefits provided to insiders. So officers, directors, key employees, major donors, to make sure that they are not disproportionately benefiting. And so there's that duty of care, duty of loyalty coming back in sort of another guise. And so some of the examples you see here, common ones are excessive compensation arrangements. And so the executive director and other key employees are deemed to be insiders. And so making sure there is a fair and objective process for setting the compensation of those folks. That is one particularly for high salaried individuals like college and university presidents or healthcare executives, the IRS is keenly focused on. And there are sanctions and ultimately revocation of exemption that can happen if you don't follow those rules. Similarly, private benefit is the same concept, the use of the income or assets of the organization to benefit either an individual or a small group of people. And so, here, the kinds of things you might see is, a targeted donation from a donor saying, I want to give to this scholarship fund, but you have to give a scholarship to my grandchild if I give this restricted contribution. And so that's the kind of thing that would be deemed to be a private benefit. So if that individual is not otherwise in the charitable class of persons that can get a scholarship using the resources of the organization for those kinds of restricted private purposes can ultimately cause the organization to lose its tax exemption. And if you're providing that private benefit to anyone who is not within the charitable class of individuals that the institution serves, you can have private benefit. There are also a number of what are deemed to be best practices that draw on these concepts of duty of care, duty of loyalty in the organization's 990, the annual tax form that it files with the IRS. The IRS theory is that an organization that has strong governance practices is more likely to comply with state governance rules as well as the provisions of Section 501(c)(3). So it's more likely to be compliant with the law if it has good governance practices. So the types of things the IRS wants to know is, do you have a board that's independent? Making sure you don't have an insider board of a group of people that are all related by family or business relationships. Does the board actually govern, or have you delegated those duties to some other group? Are you paying attention to whether there's fraud? And do you have a process to monitor that? And are you doing good record keeping? So that if anybody questions what you've done, you can demonstrate that you do have those good governance practices and that you're actually following them. And when you have conflicts, you use your conflict policy. So there's some of the kinds of things the IRS will ask on your 990. They're also very concerned about the types of policies you have. And depending on how large your organization is and what you do, you may or may not have all of these policies. They are not mandatory, but the IRS considers them to be indicia of a well-governed organization. So they want to know, did your nonprofit actually board review the 990 before it was filed so that the board is aware of what is being reported to the IRS and that it comports with what your understanding actually is as a board member of what's going on at the organization. And then do you have policies that allow the organization to be a well-governed policy, a conflict of interest policy that ensures that duty of care and loyalty is followed, a whistleblower policy so that the board is able to, from a risk management standpoint, manage any wrongdoing that occurs, record retention, executive compensation, again, back to that duty of care to make sure that compensation is fair and reasonable. And if you're engaging in joint ventures, particularly with for-profit entities, that the deal in that joint venture is objectively fair to the nonprofit and the for-profit partner is not unduly profiting at the expense of the not-for-profit. And that comes up a lot in healthcare settings when you have maybe for-profit physician practices partnering with hospitals. For more of your mom and pop nonprofits, they probably won't have a joint venture policy, but probably should have the rest of these. Okay, so our local headlines and national headlines have given us a couple of really good examples of these policies in action. And I don't think my video is going to play. Let's see. You may or may not have sound. I don't think you're hearing sound. But if you've been reading the AJC recently, you are probably aware that Morris Brown, one of our HBCUs, fired its president and then a week later rehired him, and which is a rather unusual circumstance. And the reason they rehired him is because they found that they did not follow the rules. Um, and so let's talk about what happened. Next slide. Okay. So what happened? Why did this very unusual thing happen with Morris Brown's president? Like most college presidents, Dr. James had an employment contract, and there are terms in that contract about when you can be fired and what has to happen before the board can dismiss you. And it appears to be that the board did not review that contract prior to firing the president and may have triggered, liability as a result. So under the duty of care, they didn't look at the contract. I don't know if they consulted with outside employment counsel, but based on how this went down, like my guess would be probably not. Did they actually comply with the contractual obligations again? Because of how this went down, I'm going to guess probably not. And the reason they fired him is allegedly because he did some bad stuff that may have involved sexual harassment or otherwise behaving badly towards some individuals. I don't know if it's true, but if that actually happened, there was a whistleblower policy, most likely. Did they follow that policy? Did they actually do an investigation of those claims before acting? Again, my guess is probably not because of the way this went down. And so what happens, as a result? When you don't follow the rules, you cause reputational damage. And sometimes as a nonprofit, your reputation is the most valuable thing you have. Potential lawsuits by the president suing for breach of contract, potential lawsuits by the people who were wronged. And so when you don't follow the rules, there's all sorts of legal risks that can result from that. Loss of confidence from donors, alumni, your students, your other constituents. And because this is an organization that requires legal accreditation and they're going through their accreditation process, I would have to think this has a negative impact on their accreditation process. And so, not following the rules has really serious consequences. Real quickly, just one other example. Everybody probably knows the Metropolitan Opera. They have run deficits for years and years, and they're in a bit of a financial death spiral after a board that looks like they didn't pay attention to a lot of financial things. They've rated their endowment over and over, and endowment generally you only spend the income, not the principal. But this is what happens when a board that's asleep at the wheel and isn't asking the right questions and may overly rely on financial advisors, goes on for years and years in that manner. They're looking at potentially laying off, a large percentage of their staff, reducing their program offerings. And so while not everything, is a financial issue these days, a lot of things are. And so the kinds of questions you're asking in board meetings about the budget, about budget assumptions become very, very important. I won't go through all these questions because I know we have some other panelists that have some really important things to talk with you about today. But if I can leave you with kind of a parting thought on this one, it's that have financially literate people on your board. It's more important than ever. And make sure there are people who are willing to speak up, challenge assumptions from staff, ask good questions of the auditors in that audit committee meeting every year, ask good questions of the outside financial advisor if the organization has one running their investments or endowment funds. Because finances have become critically important in this uncertain environment. And the last thing I will leave you with is the slippery slope of being a lawyer on the board. And so it probably starts out with you being put on a board because they decided they needed some lawyers on the board. And then one day the executive director will call you and say, "Hey, I have a quick legal question," which becomes, "Hey, we're going to terminate somebody tomorrow. Can you look at the separation agreement?" Whether or not you're an employment lawyer. And you can sort of slide very easily into becoming the outside general counsel for that organization, especially if they're smaller, without meaning to. This creates risk for you as their lawyer, maybe, or as their board member, maybe. It also creates risk for the nonprofit when there are not clear expectations. And so my strong advice to you is lay out the expectations on the front end. What kind of legal issues will you handle for the organization, or are you not going to be there on call for legal issues at all? So set out those expectations on the front end. If you do decide to take on a legal issue, even if it's pro bono, have an engagement letter that says what the terms of your engagement are, what you will handle, what you won't. Make sure you're running conflicts checks, even if it is a pro bono engagement. And make sure that if you are getting paid, that runs through the conflict of interest policy and that it's in the organization's best interest. And so lawyers on the board are always one of those slippery slopes, but having the front end conversation can save you a lot of heartache later on. And so with that, I'm going to turn it over to Andrew and Michelle to take you through some more specific examples in different contexts.
Amy, I'm going to share my screen as well. You see my screen? Great. Thanks, Amy, for that. And that's a great lead in to kind of where Michelle and I would like to take the conversation. When those things do go bad, right, sometimes they result in litigation. And so thinking through kind of how do we approach that? How do we best equip the board to deal with those scenarios is a concept that I know that a lot of people are thinking about when they're interacting with their board. So kind of thinking just at the front end, what are some situations where a good board might find itself caught up in some litigation? And Amy gave a great insight about those moments when you may have, as a board member, not followed some of your fiduciary responsibilities. But thinking through sort of at some of the higher levels, what are some situations that we kind of want to focus in for this discussion? Is some of the ones that I put here on the slide. Executive dominance, right? You may have a CEO or a head of your nonprofit board who sort of elbowed their way into sort of having a more control or dominance than you'd like, and you need to deal with that situation, or chief financial officer who's bringing some concerns about the way that they're handling the practice. Amy hit on this, and I think it's a great point, those conflicts of interest, and it's a topic that I think is coming up more and more, and that we're seeing the situations where boards don't have great conflict of interest provisions, where they're not thinking about or doing their diligence related to what these party transactions might do and the effects that it might have for liability. I put them sort of in the same vein because they often fall together, but whistleblower, harassment, discrimination, retaliation, those sorts of labor and employment disputes, where the board becomes apprised the situation where the university's president is accused of harassment, and figuring out how do we deal with that as a board and what steps we're going to take to address and figure out how do we go from here. The always nervous part that I hear about is financial irregularities, having someone come in and do some digging in your books and figuring out if there's things that we're audit that gives some pause. And then obviously deviating from your mission or having restricted gifts or donor conditions that might find yourself in a place where you're not following your charter and doing things that you were directing to as an organization. And then to sort of catch all this governance process failures when the governance of the board just doesn't follow its own process or its own procedures. Those are always fodder for situations where litigation arises because you just didn't follow the rules. And so in that sense, thinking about this litigation posture, where do things often, what becomes the fodder for those discussions? And of course, we hear off the paper trail, right? It's the minutes, it's the written notes that come out of those board interactions. It's the email threads and the communications that occur between your board members or between the board and individuals who might work for the organization. And then, in the sort of the modern age, the text messages, people forget about this, but you frequently in a group text where you're having conversations on your work or your personal device about board work, and those all become part of the paper trail. I reference this because I'm a litigator and it's something I'm constantly thinking about, but it's, when these things do come up, remembering at the front end to get those preservation, those foliation letters out to remind folks of their obligations to preserve those minutes and those emails and those text threads. You hear folks these days who say they have a cycle of deleting text messages. And so figuring out quickly and identifying and putting people on notice puts that litigation posture at the forefront. You can start putting some ideas around the individuals to start making sure that the documents and the things that you need to review are preserved. And, this is a good segue from where, Amy was talking about, but plaintiffs often target governance failures to unlock discovery leverage. And so when you don't follow those preservation requirements, when you don't ensure that the governance is there, that's where plaintiffs' counsel is going to come in and try to leverage and create discovery issues that can be very difficult, and have situations where they're using them for situations to sort of apply pressure on the organization. I know everyone here is generally familiar with attorney-client privilege. Of course, it's codified in our code at 24.5.501. Generally speaking, right, communications between a lawyer and its client are privileged. Our form books, the sort of guidance always tell us that, that really applies in situations where you seek legal counsel and you intend for it to be confidential. And I say all that because the lens of the approach that Michelle and I would like to work through and think about is how can you best preserve the SWIFT and contained privilege in a way that's meaningful for your board or for your organization to ensure that you kept all of those things as tight as possible and in the best interest of the organization. The thing to remember, though, as we before we jump into that, is that privilege is not this big force field, right? And Amy ended here, but I think it's really important to remember a lot of folks wear multiple hats, right? So you're a board member and you're an attorney, and folks come to me all the time when I serve on boards and start asking for legal advice. My firm, and I'm sure for folks that are at firms, often have a lot of rules about that. They don't want, for example, my firm does not want my malpractice insurance covering my work outside of the firm. And so there's a lot of question marks about when you start getting those questions, how do you make sure you're wearing the right hat? And so remember, though, that just because you're a lawyer, it doesn't necessarily mean that you're having a conversation, of course, is privileged. And the folks in this room know that. But remembering that really turns on that purpose and that confidentiality, and that at the end of the day, privilege can be very easily waived. And we'll talk through later a little bit about keeping a tight circle and that need to know basis. And that's really important when the board is sort of acting in reaching out and hiring legal counsel. And then sort of thinking through, in addition to those attorney-client privilege communications, how can I build in work product protections, right? Because those offer often a separate and additional layer of protection. It's not a fail-safe, but it's certainly a way to build on that. And I know Michelle is going to kind of talk us through a real-world example about how this shows up.
Yeah, thank you, Andrew. I have two examples here, and I'm an institutional lawyer. I represent healthcare institutions. So my examples are from that arena, but be assured, both of these examples did not occur in Georgia, so don't look for hospitals in Georgia that have these issues, because it didn't occur here. But the first one is where we have board chair Jones is an attorney, and his law firm represents the hospital, while he's acting as board chair. Now, I will tell you, Baker Donaldson has a prohibition against that. I cannot be a legal advisor and a member of a board. We just don't permit that. But it's not uniform. And as Amy said, it's the slippery slope. You are an attorney. They want you on the board because you're an attorney. And you can end up doing legal work. Here, the board chair was a member of a firm that did do legal work for the hospital. Part of what board chair Jones did, / attorney Jones did, was to review board minutes and edit them prior to their being approved in a final set of minutes. The Department of Justice initiated an investigation against this hospital for fraud, allegedly for buying physician practices at too great, paying too much for physician practices, which Amy referenced about, how compensation and how these kinds of purchases need to be viewed. So the Department of Justice is saying they're paying too much for physician practices. They're paying for referrals. That's the allegation against the hospital. And they subpoenaed the drafts of the board minutes because the Department of Justice is alleging that the board knew of the scheme, the alleged scheme to the alleged fraudulent scheme, and that these board minutes were essential in them making their case. Now, of course, the client said they were attorney-client privileged. They were attorney work product, and the drafts of these meeting minutes were not going to be provided pursuant to the subpoena. The Department of Justice said two things. First, they said the edits were made by Chair Jones. They were not made by Attorney Jones or Mr. Jones in his capacity as an attorney. There's no indicia, they believed, as to what would constitute privileged work or work product. Were there legends on the documents so stating? Was there billing for that legal work, if it was legal work, on the bills? And they certainly had all the legal bills. And was there an engagement letter that outlined that that was one of the tasks of the law firm / Attorney Jones? The other thing they said, which is usual in Department of Justice investigations, is we don't care whether you think it's privilege or not. We want you to waive the privilege. And that is a routine enforcement step that they take. So there's no way to win this fight. And there's also no way, when you put documents, edited documents side by side, that they're ever going to align. And so this is, the wearing of two hats and the slippery slope of not identifying what was the charge for the law firm and the attorney. The second example, again, not in Georgia, is a not-for-profit requested attorney advice. The attorney was properly retained. The legal advice was properly given. It was received properly by the board executive committee and examined, and they took action on it. And separately, the executive director of the not-for-profit sent the legal advice, which was contained in an email, so that's just a flick of a button, to the entire membership of the organization. It's a membership organization. And in the view that the members should know what legal advice was being provided, and that was a way to ensure transparency. So I think Andrew might want to comment on breach of privilege.
Yeah, no, that's a great segue. Thank you, Michelle. The role this kind of really set the tone for, I think, or you and I were hoping to take with Brisbane. That's really talking about how to think about privilege and what are sort of the ways that you can use, and I use the container here to figure out where should that privilege sit, and how should you be thinking about what are situations where you might want to go to a smaller group as opposed to just an board. In a lot of senses, it's pretty common for a board to retain outside counsel or to retain somebody to come in and do an investigation. But there's an increased use, and I think a healthy use of using special or ad hoc committees and figuring out a way to take that privilege and put it in a smaller box. And I've highlighted on the slide, and Sean, I can talk through some situations where that really might make sense for your board. And that might be when you're in a situation where you have senior leadership that is maybe part of that issue. I know on boards that I've sat on, sometimes senior leadership is in the room, right? For many portions of the board meeting, because they're providing updates, whether they're giving information or they're there to answer questions that the board might have about the operations of the organization. And so if you've got a senior member that's sort of in the room all the time, there might be some sensitivities about how do I sort of keep this box small. A lot of times too, board members, people are friends, right? We in our colleagues and folks that are in our inner circle to be part of organizations because we have a shared interest, right? We might be interested in, joining a nonprofit because we care about the same space. And so those can create sometimes, difficult situations because you have friends or folks that you care about or that you're sort of inner circle. You've got to build some barriers around them. And so using special or ad hoc committees might be an opportunity in those scenarios to sort of be thinking about it. There's also some times when, you talk about public integrity and sort of what gets out in the space, that you're really sensitive about what might get out to the world. You have a whistleblower, or there's some self-reporting issues. Michelle just talked about government inquiries. There's situations where you're trying to be really careful and narrow about who's sort of looking into all of those things and where is outside counsel or your counsel's challenge or charge to get to work. And then we keep talking about the party-related transactions, right? Those conflicts of interest. It might be situations where you're concerned that maybe a board member had a conflict of interest and you want to sort of think through them. And so it might be your fellow board member, right? There's some thoughts and causes for those. These are just different containers that you might think about. Kind of peeling back a little bit more, why or when you might use them. So in a lot of senses, and folks know this, you need to keep that sort of need to know circle very small. In the modern age, folks screenshot text messages, or it's very easy to click forward or an inadvertent reply all. I've seen a lot lately where companies will use distribution lists, and they, the distribution lists might have very similar names, and you might inadvertently cast the net a little wider than you intend, and that might result in waiver, right? You might end up having a board member send something out to all of the constituents or all of the people that are part of the organization and inadvertently provide some insight into what the board is doing on a legal front. That related thing is that you can have a clear sort of deposit about who is the relationship and who does the attorney report to, and that builds that independence. And that's particularly important in the context of these conflicts of interest issues. Where I see this go wrong, though, and I think this is a great structure, is that sometimes organizations don't follow their own bylaws, right? So you need to make sure that you're going through your bylaws, your articles of incorporation, and thinking about how do we form a special committee? Do the bylaws dictate that the whole board has to do that? Can the executive committee do that? What do your documents say about forming them? Do you need to have a resolution put before the whole board before you put that into place? And make sure that you're checking all those boxes, because again, when you don't follow your governance rules, that might create space where your opposing party or the adversary counsel is going to try to exact some potential leverage points to try to get into those documents. Really thinking about, though, when you do that committee structure as a sort of larger board or as counsel that's helping think through them, you have to be very deliberate in sort of defining that scope, right? That the committee is being formed for this very limited purpose and what it sort of charges as this ad hoc structure. Maybe perhaps giving them authorization to retain that independent counsel. They really are the ones that are in space to have those situations. educated board. And then finally, sort of making sure that you talk to the committee about the confidentiality and about the need to know. Sometimes, the committee will want to share information with the larger board, and you can't do that, right? Unless they're part of that ad hoc committee, you have to keep that bubble tight. And it's advising those folks that are within that orbit about how to think through those moments and how to really make sure that you're ensuring that your need to know stays small. And I think Michelle's probably a good chance to talk through some more of those real world examples that you and I were chatting about earlier.
Yeah, this is a good segue. This is something that did happen in Georgia and is public, albeit a long time ago. So we have St. Elsewhere Hospital, small hospital, going to be acquired by St. Simon Hospital, large hospital. And in Georgia, there is a statute that requires a filing and a public hearing when you're having these transactions. And so the first point I want to make is that, yes, we have the ABA model rules. Yes, we have the Georgia Code of Professional Responsibility, but there are conflict of interest statutes or conflicts of interest prescriptions within other statutes. And as an example, this filing that has to be made when there's a hospital transaction contains a conflict of interest for the entity where requirement where board members have to disclose conflicts of interest between the two entities, the buyer and the seller. And a lot of times that involves real estate. Conflicts of interest and real estate seem to go together. And the situation was that as part of the transaction, Big Hospital was going to build a new hospital for a little hospital, going to build a new little hospital. And the board did not know, the board of the small hospital in their vote did not know where that new hospital was planning to be built and felt uncomfortable voting on a transaction where they didn't know where their new hospital was going to be. Very reasonable. So Big Hospital did let Little Hospital know where the new hospital was going to be built. All fine and good. Everybody's happy. The board of Little Hospital holds a vote and says, we're going to go ahead and do this deal. And we agree to keep confidential where the location is going to be. A board member physician goes and buys property down the road from location, not next to it, down the road, and does let the board know that that has happened. Then the Big Hospital changes their mind where they're going to locate the little hospital. Their architect had looked at the site and realized that there was a truck stop across the street from the proposed location and decided, gee, I don't think that's aesthetically pleasing, and ended up purchasing a piece of property right next to where physician board member had purchased property. Again, all after the vote. I was uncomfortable with all of this. I think everybody was uncomfortable with it. Luckily, in this situation, we just disclosed it all to the Attorney General and said, help us, what do we need to do about this? Ultimately, the Attorney General decided there was no conflict with the real estate transaction of the physician board member because all of the events occurred after the board vote. There was no transaction that influenced the board vote of small hospital, and the purchase of the real estate in the large hospital was not influenced by all of these transactions. I think this could have come out another way. Essentially, the physician board member made a tremendous amount of money because all the hospital physicians wanted to relocate to be near the new hospital. But it was an interesting time. So take homes are, you need to know your industry, banking industry, hospital industry, where are there other conflicts of interest rules? And it might be in codes of conduct. For instance, if you are a medical device manufacturer, there is a code of conduct for medical device manufacturers. We've only got 5 minutes left. I want to impose, if I could, and say a couple things about insurance. Most conflicts of interest are the most litigated claims against attorneys. They are the most costly claims. And those claims professional liability claims are increased if there is a conflict of interest claim. So it's a significant professional liability risk. Many non-for-profits that I have served on, not as a lawyer, but as a board member, don't have insurance, particularly smaller ones. If they have insurance, it might be for slip and fall, but not for D&O coverage. If they have D&O coverage and do have good insurance, they may not offer attorney professional liability insurance. If they have all the correct insurance, insurance companies will not insure, they will exclude conflicts of interest from insurance coverage. So please don't just take that as knowledge. Please don't resign everyone from your board service. It's critically important to our community, but be aware and check and see if they have insurance. Andrew, back to you.
Thank you. Yeah, insurance obviously always the part of the conversation. I know we're coming up on time, and so I'm going to sort of end in a space that's comfortable for me, but it's thinking about how to, when you do have to get in that space where you're running an investigation, whether you're the lawyer that's sort of charged with it, you're talking with your outside counsel about what that looks like, or you're advising your general board or that ad hoc committee about how are we going to start digging into this. You really should be counsel directed, right? You really want to leverage the expertise from your counsel in thinking about how to do them. And that purpose-driven approach is important and pragmatic because it also helps maintain that privilege, right? Part of the metric and the way that we look at whether or not communication is in fact privilege is what's the purpose behind it. So having counsel as part of that discussion and a litigator who understands sort of the ways that you can ensure that those pieces remain privileged is an important part of just that overall thinking. I would be remiss if I didn't talk about, the Upjohn warnings. Think back to law school when you were in ethics and you were hearing about making sure that your counsel had discussions with those who was interviewing and explaining who counsel represents and making that perfectly clear. I think that's a challenge sometimes, particularly in nonprofits, that maybe don't have some of the same structures as some of the larger corporations or entities. Really making plain to those that you're interviewing about who is represented in the discussion and whose sort of interests those lawyers are working to sort of adhere to. I often hear, and I'll sort of end with, folks, I see slap on documents all the time, like privileged and confidential or attorney work product. When courts look at those documents, that's certainly one thing they look at, but what the law says is it's not just positive. And again, part of that networking and that what keeps those documents privileged is keeping the need to know very small. And so ensuring that your distribution list for who's getting that information is really tight is an important part of ensuring that privilege is maintained and doesn't find its way outside of your committee or your board. I know we're very close on time. Michelle, Amy, and I we're so happy and pleased to have the opportunity to talk with you all. I'm sure that we would all welcome further discussions for the folks that were listening today or in the future to talk about these topics. And I will send it to Michelle and Amy the parting word. Thanks so much for spending your lunch hour with me and with the others today.
Yeah, any one of us is happy to answer any questions.
Yeah, and I will say, both as attorneys who advise boards and serving on boards yourself, understanding these rules And in many cases, as the attorney on the board, being the keeper of these rules, making sure that your fellow board members and the executives at nonprofits um, follow the rules, even if you're not their lawyer, even if you're just a board member, bringing up these rules and ensuring that they're followed, you are doing a service to the board and the nonprofit by really helping to mitigate risk for that organization. And so hopefully you have a few more tools in your toolbox after today, to help do that on the boards that you advise.
Thanks, everybody.